Whenever someone creates a will, in order for the will to be carried out after you pass, the will has to be admitted to probate and open a probate proceedings. Those probate proceedings are subject to a lot of procedure, and one of the important steps of it is that notice is required to be sent and hearings required to be scheduled for any step of the process. An important part of probate proceedings is that there are procedures involved with admitting the will, appointing the executor, filing an inventory, approving accountings, verifying beneficiaries. Each one of these steps requires a court hearing and notice to be sent to all interested parties. And according to probate procedure, the interested parties to probate are not just the beneficiaries under a will, but it also is the heirs of your estate. Because if that will didn't exist, the heirs would be the ones receiving the property. So they're given a chance to review your will. And in fact, they're given a copy of the will with a piece of paper attached to it that says, if you disagree with this will, show up at this date and time and file your objections. That certainly incentivizes anyone who has literally nothing to lose to show up and increase legal costs to object to the proceedings or to just generally make life difficult for everyone else in the proceedings. The costs of defending probate objections can easily make attorneys' fees cost so much that it starts to take a considerable chunk out of the actual estate. If you are in a position where you need to disinherit an heir, if there is a family member you do not want to receive any property, it's generally a good idea to avoid probate. The way to do that is either through beneficiary designations, to designate on your accounts directly who you want your beneficiaries to be, or to set up a trust. And a trust would be the recommended vehicle if you want to write down your intentions, designate someone responsible for carrying out the winding up of your affairs, and to ultimately distribute your property as you see fit. Under a trust, it's not subject to court review or a probate process, and because of that, a disinherited party would never otherwise be entitled to a copy. If someone isn't included in a trust, then they may never know about it. All that being in the case, if you're in a situation where you are not wanting to give equal distribution to children, or you're wanting to make sure that a family member does not receive anything, it's a very good idea to talk to your attorney to put together a plan so that the administration process can go smoothly and without contest and without undue expenses or objections.